Okay. Come out.
Alright, you can go and give me your hands. You're under arrest.
For what?
I have a warrant for your arrest.
For what, sir?
Misuse of 911.
On June 8th, 2023, a Volusia County woman called 911 and reported her neighbor's child was drowning. No child was drowning. There was no pool. 2 deputies were hospitalized in a T-bone collision while responding under emergency conditions. 6 days later, a judge issued a warrant for her arrest. That warrant and the law behind it is what this analysis examines.
Drowning?
Yeah.
411, so cut chest off. Fort Smith Boulevard, Northwood.
Copy.
Sorry. Transgender.
Copy.
63 is going through.
Copy.
43 Central, same traffic.
43, copy.
Okay.
Bro,
Bro, get away.
This guy came out and said it was his house.
Oh, he doesn't know.
Did you just hear a noise? Is this the right one? He's back there in the back corner.
Ring?
Yeah, that's her right there. But she said the neighbor's right here, but the one. Okay. I have a feeling it's going to turn. It's on the porch.
There was someone on the back porch. I think so. There was a woman sitting on the back porch. She's still sitting on the... Hey, did you call us?
Yes, ma'am.
What's going on?
They're right in front of me right now.
What's going on?
All right, I appreciate that. Thank you so much.
What happened?
I don't have a phone.
Okay, sorry. Is somebody drowning? What's going on?
I just heard a lot of stuff, and I recorded it, and the kids were like yelling, I'm gonna die, and everything, and I just recorded it, and it was so scary.
Long story short, she called it a drowning. So that's why we're all coming.
That's her excuse.
They're,
Because she was yelling at the kids, talking about they being too damn loud.
yeah, that's what it sounds like.
I don't, like,
Yeah.
it's 4 o'clock. What time our kids gotta be quiet?
The deputies over there, they're talking to her. There may be criminal charges just because of her making a false police report. I don't know.
Yeah, y'all don't need to do that, sir.
I mean,
I mean, y'all,
we had a deputy crash and get hurt coming to this. So, yeah, that's.
Thank you, boss.
Yeah, appreciate it.
Did they end up finding a dog up there?
Yeah, that guy's in the house.
It'll take a while. Just look at it. It was just very scary. I called my husband, I called my dad, I called my mother.
Is this playing?
Everything is a video. Everything.
Okay, I don't hear anything. Is it playing?
I heard the white yell at the kids, and I just have so many things.
Okay.
Just so.
But we already went over there. Everybody's fine over there, okay? Just to let you know, there's no kids that are hurt, nobody drowned, nothing like that, okay?
Florida Statute Section 365.172, subsection 14, defines the criminal threshold for 911 system abuse. The statute requires 3 elements: access to the 911 system, a false report or alarm, and the reasonable foreseeability of an emergency response. A baseline violation, a single false call, is a first-degree misdemeanor carrying up to 1 year in county jail under Florida Statute Section 775.082. However, where the false report actually triggers an emergency deployment, and that deployment results in injury, prosecutors may pursue the charge as a third-degree felony carrying up to 5 years in state prison. That is the charge filed here. The crash at the intersection of Providence Boulevard and Fort Smith Boulevard, 2 deputies hospitalized, is the factual predicate for the felony classification. The operative word in the statute is knowingly. Florida's 911 misuse law does not criminalize good faith mistakes. It targets intentional false reporting. The Volusia County Sheriff's probable cause affidavit addressed this directly, stating that Probable had no good faith reason to believe a child was drowning and intentionally reported false information. When deputies asked her on scene whether she had actually witnessed a child drowning, she confirmed she had not. That admission is the mens rea anchor for the entire criminal case. The distinction between an honest mistake and criminal conduct is the difference between a neighbor who misinterprets children's laughter as distress and one who fabricates an emergency to generate a police response.
Okay.
Am I sure?
I'm sure, because we already went over there. So I'm just letting you know. They're okay. The kids are okay. They were playing in a blow-up water slide thing. Okay?
Because all I hear is, I'm gonna die. I'm gonna die.
Well, maybe they were playing, like, joking around.
Okay.
Did it sound like somebody was hurting somebody else, or? Because when we saw back there, there's just kids playing on a water slide. They're playing.
So I did something wrong. I was just worried.
No, sweetheart, you didn't do anything wrong. It's an emergency. We had to make sure there's no child drowning. So the call came out as an 8-year-old drowning, and we get here and we don't know what's going on. So we just determined that they're fine, and you were scared because you heard something that was possibly somebody getting hurt. But I'm just letting you know they're all fine, so everything's fine.
Are y'all okay with her? Like, do you usually get into it with her?
Huh?
Do you usually get into it with her or anything?
First time.
First time?
First time. So I'm coming from work, and my girl texts me, yo, the lady's yelling at the kids, telling them to be quiet.
Now that you're saying this, it seemed like she kind of like made that up.
You went back there?
Back there?
Yeah.
I look back there. It looked fine to me.
There ain't no pull back
The kids
there.
weren't saying that. I was listening. I was back there with the kids, and the kids were playing, and the kids heard her screaming, saying, "Stop it!" Something like that. She was saying, and I'm wondering who she's talking about. I said maybe she's going through something in her house.
Yeah, like somebody over there or something.
So
it was just weird because I never heard from them ever.
I didn't say nothing, and I'm like, who is she talking? No. And then she kept saying, "Stop it."
Yeah, it was just weird, bro. Never had anything.
Kids in your backyard playing, right?
Yeah, and I was with them.
She just heard screaming and yelling, didn't see anything, got worried because she knew there was kids playing in the backyard, and for some reason called 911 and said that there was a child drowning.
She said no. She kept saying, "I'm going to call the cops."
Yeah.
So
and then when I got here, I said, "Yo, what's going on?" She said, "I'm calling the ambulance right now." I'm like, "What?" Like I don't know what the hell. And then right when I came back over here, that's when y'all pulled up.
Okay. I let her know that everything's fine, the children are fine, but you guys were having like a party or pool party?
No, it's only 3 kids back there.
No,
okay. She just heard a kid yelling, I'm going to die, I'm going to die. So I said, they're probably kids playing, and
no, it's a water slide, a small slide.
Yeah, that's what I told her. Everybody's fine.
We didn't even have a pool back there.
Yeah, water slide. All right, sorry to bother you guys.
Nah, that's all good. Thank you, guys.
The woman called 911 again the very next day.
The warrant for Robles' arrest rests on the probable cause standard established in Illinois versus Gates, 462 United States 213, 1983. Gates replaced a rigid 2-pronged test with a totality of the circumstances analysis. Courts consider all available evidence collectively. No single factor is dispositive. Here, the totality was substantial. The 911 recording, Robles' own admission to deputies, the neighbor's corroborating account, the physical evidence, no pool, no drowning, and 40 prior calls targeting the same address. That pattern of conduct is legally significant. Repeated false calls establish intent and negate any claim of good faith belief in an emergency. A single false call is an incident, 40 calls is a course of conduct. The arrest itself was executed pursuant to a judicially issued warrant. Under the Fourth Amendment, a warrant requires a neutral magistrate to make an independent, probable cause determination before a person is seized. Once that determination is made and the warrant is issued, deputies executing it have no obligation to independently reevaluate probable cause in the field. Their function is lawful, warrant service, nothing more is required. The force applied during this arrest, verbal commands, handcuffing, escort, is evaluated under the objective reasonableness standard from Graham versus Connor, 490 United States 386, 1989. Graham requires courts to assess force from the perspective of a reasonable officer at the moment of the decision, not with the benefit of hindsight. A non-resisting subject, no weapons present, warrant in hand, the force used was proportionate. Robles' spontaneous statements during the arrest denials, alternative explanations, claims about domestic violence were made voluntarily, without interrogation. Under Berkemer versus McCarty, 468 United States 420, 1984, Miranda protections attach upon custodial interrogation, not to voluntary statements made before any questioning begins. Those statements are fully admissible. More importantly, they reveal an attempt to retroactively reframe the 911 call as a domestic violence report, a framing inconsistent with the recorded call itself, which focused on a drowning child. Beyond criminal exposure, this case raises a proximate causation question in civil tort law. When a private actor's intentional false report foreseeably causes law enforcement to deploy under emergency conditions, and that deployment results in physical injury, the false reporter may face civil liability under state negligence, doctrine, or intentional tort theory. Section 1983 of Title 42 does not apply. Robles is a private actor, not a state actor. However, Florida recognizes negligence per se where a statutory violation is the proximate cause of a plaintiff's injuries. A conviction under Section 365.172 could establish that standard in a civil action.
This time claiming the neighbor's dog was barking in a threatening tone. Officers responded, again finding no emergency. But after reviewing her long history of false reports, it wasn't until a few days later that they arrested her on 41 counts of misusing 911.
Hey, Nate.
How may I help you?
Hello, can you come talk to me for a second?
Yes, sir.
We're trying to figure something out here.
Okay. How may I help you?
All right, you can go ahead and give me your hands. You're under arrest.
For what?
I have a warrant for your arrest.
For what, sir?
Misuse of 911.
Sir, I heard what I heard.
Okay, you can go ahead and turn around.
Are you serious?
Yes, ma'am.
Can you please explain to me why? Jose!
You have a warrant.
Me están arrestando. My husband heard it too.
All right. Okay, you can come with me.
I'll explain it to your husband. Hello, how are you, sir? Pretty good.
Motor 43 Central. Come on.
She is being placed under arrest. For what?
I have an adult male. I'm sorry, I have an adult female secured. Come on, let's go.
Yeah, resulting in
Let's go.
motor vehicle accident.
Motor vehicle
Come on,
accident.
let's go.
No, result. So, essentially,
One motor 43 Central.
Sir, I don't even drive underneath my house.
Yep, can you go ahead and get confirmation?
Sir, I called
I'll
about the
explain.
neighbors.
Okay.
That it sounded like there was domestic violence going on. I don't even drive underneath my house because I have health problems.
Stand right here for a second.
Yes, sir.
Do you have anything on you?
No,
Gonna poke
sir.
me, stick me, hurt me?
No, sir, I don't leave my
Guns,
house.
drugs, bombs?
No, sir, I
Okay.
don't use drugs at all.
Okay.
I just,
I ask everybody the same, because
No,
if we
I'm
get to the
nervous
jail and they
because-
find something.
I don't drive. I don't leave my house.
Okay. Well, the judge issued you a warrant for your arrest for misuse of 911.
For when?
For last week when you called in about the neighbor's kids possibly drowning.
Drowning.
Have a seat.
I said domestic violence.
Well, apparently you told the 911 call taker that the kid next door was drowning. And when you did that, it activated a full emergency response to that address and caused an accident when a deputy was clearing an
The
intersection.
kid was screaming, so Dad, get off of Mom. And the guy came over and went into our backyard and everything.
Okay. Well, we have the 911 tape. We have it in evidence. Okay. That's why the judge sided with us and issued a warrant.
Sir, I did not do anything. I swear to God, I would never do something like that. I don't leave my house or anything. I was trying to not be a standbyer and listen to a kid suffer and hear him dad beat the mom.
Okay. Well, as a result of what you called 911 about, the judge issued arrest and determined it was a misuse of the 911 emergency system because your call resulted in 2 deputies getting injured in a major crash.
The Volusia County Sheriff's deputies receive an A-. Warrant execution was professionally conducted. No weapons drawn, transparent communication with both the subject and her family, and measured de-escalation throughout a potentially volatile encounter. The minor deduction reflects early on-scene language that affirmatively reassured Robles she had done nothing wrong, technically inaccurate given the criminal investigation already underway and potentially undermining to subsequent prosecution. Fabiola Robles receives a D. The pattern of 40 prior calls, all targeting the same neighbors, all noise complaints, all producing no law enforcement action, establishes that the drowning report was not confusion. It was deliberate escalation. Florida Statute Section 365.172 requires knowing false reporting. Her own admission that she did not see a child drowning satisfies the mens rea element of that offense on its face. Compliant conduct during the arrest prevents a failing grade. Physical resistance was absent. But compliance at the point of accountability does not reduce culpability for the conduct that created the emergency. The neighbor receives a B+. Accurate account, cooperative demeanor, no attempt to exploit the law enforcement presence for retaliation. A complete record would be needed for a higher evaluation. 3 takeaways from this case. First, the 911 system is a legal instrument, not a complaint mechanism. Accessing it to compel police response for a non-emergency, regardless of motive, meets the criminal threshold under Florida Statute Section 365.172. Second, pattern matters. A single false call may produce a misdemeanor. A documented pattern, 40 prior calls, a follow-up call the next day, establishes intent, eliminates good faith defenses, and supports felony-level prosecution. Third, proximate cause extends liability. When a false report produces an emergency deployment, and that deployment results in injury, the caller's criminal and potential civil exposure expands proportionally to the harm caused, not the harm intended. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Audit the Court, for even more police interaction and courtroom content.